Sanford, Florida, 6:30 in the evening. The fluorescent lights above the courtroom hum with that cold, steady sound that makes long days feel even longer. The benches are half empty now, but the air still holds the weight of the day. Jurors sit with tired faces. Lawyers keep their posture, but you can see the strain in their shoulders. A clerk shuffles paperwork like it is just another file, another name, another case. The verdict has already been read. Guilty. 46-year-old Lisette Gonzalez stands at the defense table, hands resting lightly against the wood. She does not look at the jury. She does not look at the prosecutor. She keeps her eyes forward, jaw tight, expression contained. Not calm, contained. There is a difference. Calm is peace. Contained is pressure held in place. If you walked in right now, you would assume this is finished. Another DUI conviction, another defendant waiting for sentencing, another routine ending in a courthouse that runs on routine. But this case is not routine. Because earlier that day, under oath, something surfaced that should have changed the entire room. In Officer Michael Wagner's official report submitted as evidence, there is a number, .08, the legal limit for intoxication, the number jurors recognize instantly, the number that feels like science, precise, objective, final, only there was no breath test, no blood draw, no chemical analysis performed at all. In the footage, it comes out plainly. The officer admits she was never given a breathalyzer. He admits her blood was never drawn. No test result exists. And yet his report recorded that she tested above the legal limit, .08. When pressed, he calls it an honest mistake, a paperwork error, something that should not have been there. Now here's the moment that tells you what kind of story this is. Because the state then has a choice. When a core detail in an official report is exposed as inaccurate, the responsible move is to acknowledge it cleanly, isolate the damage, and treat the case with caution. But the prosecutor does not retreat. She does not concede that the report is compromised. She defends the arrest. She defends the officer. She defends the case, and a jury convicts. So now, at 6:30 in the evening, Lisette stands there convicted, while the courtroom tries to move forward like nothing happened. Her attorney stands and makes a motion you do not see every day, a judgment notwithstanding the verdict. In simple language, he is asking the judge to override the jury's decision, to say the evidence was not legally sufficient or the integrity was too damaged for the verdict to stand. Judges are cautious with this. They respect juries. They protect that boundary. Courts rely on juries the way buildings rely on beams. You do not pull a beam out unless you are sure it is rotted. The judge pauses. He considers it. He denies it. The guilty verdict stands. And for a moment, you can feel the door closing, the kind of closing that does not need a sound. Lisette's face stays controlled, but you can tell she has just absorbed the weight of a guilty verdict like it is physical. Then the judge looks down again, because the docket is not finished. There's another case for Lisette Gonzalez, driving with a suspended license. 2 months after a DUI arrest, she was ticketed again, this time for driving when her license was suspended. On paper, that seems simple. Drive while suspended, face consequences. Most people hear that and assume they already know the story. Except the only reason her license was suspended was because of the paperwork filed after the DUI arrest, the same paperwork that contained the phantom .08, the same report that implied a scientific result that never existed. Now the error is not just a detail in a file. It has consequences, real ones, months of suspension, the kind of administrative punishment that hits your life quietly. You cannot drive to work. You cannot pick up your child. You cannot handle your own errands without fear of being stopped again. And now the state is trying to punish her for driving under a suspension that was triggered by inaccurate paperwork. This is where the judge leans forward slightly. Not dramatically, just enough to show the room he is looking at this differently now. He addresses the prosecutor. In the footage, he wants to be enlightened. He wants to understand how the state intends to proceed, because the officer admitted the mistake. Uncontroverted, meaning it was not disputed. It was the truth in the record. And the prosecutor, instead of stepping back, digs in. She insists it was a mistake, that it is not perjury, that it does not change the core case. And this is where the judge's patience begins to thin. Because this is not a typo. This is not a misspelling. This is a chemical measurement, a number that implies a test occurred, a number that carries scientific authority, a number that influences jurors, a number that triggers administrative action. If you put a number like that in a report, the system treats it like truth. The judge dismisses the suspended license charge, just like that. And that dismissal is not small. It is a signal. Because once the judge dismisses that charge on the basis that the suspension was caused by inaccurate paperwork, the logic swings back to the original conviction like a door on a hinge. If the paperwork is flawed enough to collapse one case, how can it remain reliable in the other? The judge sits back, silent, thinking. This is courtroom psychology in real time. A judge recalculating, not for show. Because he has to. He replays the testimony in his mind. He replays the officer's explanations, the admissions, the hesitations, the way the officer handled questions. And then the judge says something that is not legal language. It is human language. He says the whole case was fishy. Fishy. That word matters. Judges do not like to say things like that unless something has truly bothered them. Fishy means it does not smell right. It means the narrative is strained. It means someone is trying to make a story hold together that does not naturally hold. He recalls how the officer basically tripped over himself just to arrest this lady. Just to arrest her. That phrase matters too, because it suggests effort. It suggests forcing. It suggests a conclusion looking for justification rather than facts leading to a conclusion. The earlier motion comes back to life. Judgment notwithstanding the verdict. He denied it before. But that was before the second case forced him to follow the chain reaction, before he saw the dominoes, one inaccurate entry, a license suspension, a second charge, months of consequences. And now a prosecutor standing in court defending it as if it is normal. The judge looks up, and he grants it. The guilty verdict is no longer standing. The courtroom freezes in that way that tells you everyone knows something rare has just happened. The prosecutor reacts quickly. She challenges him. Are you granting this because you do not agree with the state's decision? That question is not just a question. It is a push. It tries to frame the judge's action as personal disagreement rather than legal necessity. And the judge shuts it down. No. In fairness, now that I consider what the officer testified to and how many times he tripped over himself with no real probable cause, you are done. Motion granted. No written order. Do you want to appeal me? That line is not a taunt. It is not theater. It is the judge drawing a boundary. If you want to contest this, do it properly, upstairs, on appeal. Lisette Gonzalez exhales. It is small, but it is visible. The release of a body that has been holding itself together. She does not celebrate. She does not cry. She gathers her things and walks out, free of all charges, convicted minutes earlier, free now. If you want to understand why this clip went viral, it is not because people love legal procedure. It is because people understand one thing instinctively. Credibility matters. The justice system runs on credibility the way a car runs on fuel. And credibility is carried by documentation, reports, testimony, consistency. When a police officer writes a number like .08 into a report, that is not just ink. It is authority. It is the system moving. Paperwork triggers action. Reports trigger suspensions. Suspensions trigger charges. Charges trigger trials. Trials trigger verdicts. If documentation falters, everything built on it becomes unstable. Now, rewind the story to where it actually begins. Not in a courtroom, on a roadside, flashing lights, a car pulled over, an officer approaching a driver. In the footage and testimony, the officer says he observed what he believed were signs of impairment. The state builds on that. It is the usual foundation. Observations, field sobriety exercises, the officer's judgment. DUI cases can be built on observation alone. That is true. But there is a difference between a case that is honestly built on observation and a case that is built on observation but dressed up with a scientific number that never existed. That number changes how people hear everything else. Because observation can be debated. It is subjective. It depends on interpretation. A number feels different. A number feels like confirmation. A number feels like certainty. So when .08 appears in a report, it adds gravity to everything the officer says he saw. And jurors, being human, feel that gravity even if they do not say it out loud. Then, under cross-examination, the officer admits there was no test. That is the crack. But cracks do not always collapse a verdict immediately. People want to believe mistakes are rare. People want to believe the core story remains true. People want to believe the system is mostly accurate, so the jury convicts. And that is where you see the role of a judge as a safeguard. Judges respect juries, but judges also have to protect the law and the integrity of the process. When a case crosses a threshold where fairness is compromised, a judge can intervene. The judge initially denied the motion, which tells you he was not chasing drama. He was doing what judges often do, giving deference to the jury. But the suspended license case changed the shape of the problem, because it made the error tangible. It was no longer just about whether the jury heard something inaccurate. It was about consequences that had already happened for months because of that inaccurate entry. Now, let me ask you something, and I want you to sit with it for a second. If there was no breath test and no blood draw, how does .08 appear in an official report? Is that carelessness? Is that negligence? Or is it something deeper? Because harmless errors do not suspend someone's license for months. Harmless errors do not generate new criminal charges. Harmless errors do not create the impression of scientific confirmation where none exists. This was not a typo like a wrong postcode. This was a scientific claim without science. The prosecutor's role here is why people get heated. Because once the mistake is admitted under oath, there is a responsibility to handle it with care. Instead, the prosecutor defends it. She frames it as harmless. She resists the implication that it undermines the case, and in doing so, she ties the credibility of the state to that incorrect entry. That is why the judge turns toward her. That is why the tone shifts. Because the judge is not just looking at the officer anymore. He is looking at the state, and he is deciding whether the state is acting fairly. This is the psychology people miss when they watch these clips. Prosecutors are trained to advocate. They are trained to win. But prosecutors are also supposed to be ministers of justice. That means they have to care about fairness and integrity, not only outcomes. In moments like this, you can see the tension between those two roles. Advocacy says, keep the case alive. Justice says, admit what the evidence really is. The prosecutor chooses advocacy. The judge chooses fairness. Now imagine being Lisette in that room. You have been arrested. You have gone through court dates. You have paid legal fees. You have carried uncertainty for months. You have just heard the word guilty. You have just had your last motion denied. And then suddenly, the judge looks at the second case and realizes the entire chain reaction is built on a false entry. You hear the suspended license charge get dismissed. You hear the word fishy. Hope flickers, but you do not let your face move because you have been disappointed too many times already. Then, you hear the judge grant the motion. Your conviction is erased. The whiplash is huge. But the relief does not come with celebration. It comes with exhaustion. Because even when the system corrects itself, it does not give you back the months. And here is where the story becomes bigger than one defendant. Because Lisette had a lawyer who pressed. Lisette had a judge who paused. Lisette had a courtroom with enough friction for the truth to surface. Not everyone gets that. Some people plead out because they cannot afford trial. Some people accept penalties because they are scared. Some people never get a judge who calls a case fishy out loud. This clip resonates because it shows what accountability looks like in real time. But it also quietly raises a question that makes people uncomfortable. How often does the machine move forward on bad inputs? How often does paperwork get treated as truth because the system needs to keep moving? And how often does nobody stop it? Now, if you want to understand why the judge's reversal matters, look at the chain. The officer's report contained an incorrect chemical reading. That report helped support a DUI case. The report triggered a license suspension. That suspension created a new charge. That new charge was now sitting in front of the judge. The judge dismisses the new charge because the suspension was caused by inaccurate paperwork. Then, the judge realizes he cannot logically leave the original conviction untouched because the same flawed entry is sitting inside it. That is the turning point. Not the argument, not the posture. The turning point is the chain reaction becoming undeniable. Now, outside the courtroom, the story does not end. Because the moment Lisette walks out free, the next question begins. What happens to Officer Wagner now? In the footage, he calls it an honest mistake. But an honest mistake with this kind of impact is still a serious problem. Does the department review his reporting? Does a supervisor audit his recent cases? Does anyone check whether similar entries have appeared in other reports? Is there retraining? Is there discipline? Or does it get categorized as clerical and filed away because the case is dismissed and the public attention fades? This is where Part 2 naturally lives, not in outrage, but in accountability. If the justice system depends on documentation, then documentation has to be clean. If prosecutors depend on reports, then reports have to be verifiable. If the state can remove your license based on an entry, then that entry must be grounded in reality. Now, let's talk about the prosecutor again, because this is where your viewers will have opinions. There is a difference between defending a case and defending a mistake. Defending a case means you argue the evidence honestly. Defending a mistake means you minimize a flaw because admitting it threatens your outcome. In this footage, the prosecutor appears to be defending the mistake, not by saying it never happened because it was admitted, but by treating it as if it should not matter, as if the system should just continue anyway. And that is exactly what triggered the judge. Because judges can tolerate human error, but they do not tolerate being asked to pretend that error has no weight, especially when the consequences have already hit a defendant's life. The judge's frustration is not just about the officer. It is about the posture of the state. It is the feeling that the system is trying to move forward without paying the price for its own mistake. So the judge interrupts the machine. He chooses fairness over momentum. He chooses scrutiny over convenience. He reverses his own earlier decision. That is rare. And that is why people watch this clip multiple times. Because the reversal's not just legal, it is psychological. It is a judge saying, I am not going to rubber stamp this. And it is a reminder that courts can correct themselves even late in the day, even after a jury verdict, when something fundamental is wrong. Now, if you are watching this and thinking, all right, she walked free, so what is the problem? Here is the problem. Correction in one courtroom does not automatically create prevention across a system. It fixes this case. But it does not guarantee that the reporting process changes. It does not guarantee that administrative suspensions are verified. It does not guarantee that prosecutors adopt stricter checks before trial. It does not guarantee that supervisors audit reports more carefully. And that is why accountability after the fact matters. Because if nothing changes, then this becomes a viral moment, not a lesson. Now, I want to slow the energy here without you seeing any stage direction, so listen closely. The most dangerous errors are not the ones that look dramatic. They are the ones that look normal. A number typed into a report, a form filed, a license suspended automatically. A defendant told, "This is just procedure." A new charge issued. A person's life quietly narrowed by a system that assumes accuracy. Then, only later, If someone has the resources and the courage and the lawyer and the judge, the error is exposed. This story shows how fragile that process can be, and it also shows that the state will often keep moving unless someone forces it to stop. So here is the engagement question I would want viewers to answer, because it pulls them into the moral center of the clip. If you were the prosecutor in that room and the officer admitted the report contained a chemical reading that never existed, would you still defend the case like nothing happened? Or would you step back and admit the integrity problem? Tell me what you would do and tell me why. Because your answer says a lot about what you think justice is supposed to be. Now, back to the scene. Lisette walks out free and the courtroom resets. That is what courtrooms do. They do not celebrate. They reset. Next case, next name. But the ripple does not disappear. There are now questions on the record. There is now an admission under oath that a chemical reading was entered without a test. There is now a judge who publicly called the case fishy and overturned a conviction. Those things are not nothing. They live in transcripts. They live in files. They live in institutional memory. At least they should. So if you are thinking about part 2, the story is not, did she win? The story is, what happens to the system after it is forced to admit a flaw? Does it audit? Does it retrain? Does it redesign report templates so a number like that cannot be entered without attachment? Does it change how suspensions are triggered? Does it discipline? Does it apologize? Or does it do what systems sometimes do when they feel embarrassed? Does it go quiet? Because silence is the enemy of improvement. And if you want to know why people are polarized by clips like this, it is because people project their own experiences onto it. Some people trust the system deeply and assume errors are rare. Others have felt the system's weight and assume errors are common. This clip confirms different beliefs depending on what you already carry. But there is one neutral fact you can take from it. An official report contained a scientific sounding number that was not supported by an actual test. That is a serious issue. And once you accept that, everything else becomes a question of accountability. How does the state respond when its own evidence undermines itself? How does a prosecutor respond when a key detail is exposed as wrong? How does a judge respond when fairness is threatened? And how does a department respond when an officer admits an error under oath? Those are the questions that make this story last longer than a viral clip. Now let's bring it back to the moment, because this is where the emotion lives. When the judge says motion granted, it is not just a legal phrase. It is a sudden release of pressure. Lisette's body understands it before her mind can fully process it. This is what people miss when they talk about cases like they are chess games. Defendants are human. They carry fear. They carry uncertainty. They carry the quiet embarrassment of being judged. They carry the worry about work, family, money, and what happens if the system says guilty. When that gets erased, the relief is real, but it is not clean joy. It is exhaustion. It is survival. And then she walks out, and the camera stays behind, because the courtroom is not interested in her life afterward. It is interested in files. But you are interested in the story. And the story is not finished when she leaves. Because this case leaves behind a question that does not go away. If one incorrect entry can cause months of consequences, how many people have been hit by smaller errors that never get corrected? How many cases have a number that was never verified? How many suspensions were triggered automatically without confirmation? How many defendants pled guilty because they believed the paperwork was unchallengeable? How many prosecutors defended a case because conceding the flaw would mean admitting the system was wrong? Those are uncomfortable questions. But accountability starts with discomfort. So if part 2 is about officer accountability, it begins here, in the gap between what the public sees and what the institution does next. It begins with records, with policies, with oversight, with whether this officer's reporting is reviewed, with whether similar cases exist, with whether the department and the prosecutor's office make changes quietly. Because that is how real reform happens, quietly, after the cameras leave, when people decide whether embarrassment becomes improvement or denial. And if nothing changes, then the next person will be forced to fight the same battle, not because the system hates them, but because the system is designed to keep moving unless something forces it to stop. That is the final lesson of this story. The system corrects itself only when someone makes it. Lisette had a lawyer who pushed. She had a judge who paused. She had a moment where truth and consequence collided in the same courtroom. And she walked out free. But what happens to the officer? What happens to the prosecutor's approach? What happens to the department's safeguards? That is the story still waiting. And if you want the next chapter, the question is simple. Did this case end as a headline, or did it become a warning that changed procedure? Because justice is not only about verdicts, it is about whether the process gets cleaner the next time. And what happened after that evening in Sanford may matter just as much as what happened in open court.